The session began in the morning, but up next for the next 3 hours, the evening debate over Article 2 of impeachment against Richard Nixon.
The committee was debating the Wiggins motion to strike paragraph 3, and those in opposition to the amendment had consumed 8 minutes, and those in support of the amendment had consumed 5 minutes. And I now recognize the gentleman from California, Mr. Wiggins, for such time as he may consume out of that time.
Mr. Chairman, I yield 5 minutes of my time to the gentleman from Iowa, Mr. Maine.
Mr. Maine is recognized for 5 minutes.
Thank you, Mr. Chairman. Those of this panel who would impeach the President for setting up the Special Investigative Unit would have us believe that there was just no national security involved in this at all. Well, then why was it called the Plumbers Unit? It was called the Plumbers because its purpose was to plug leaks of secret information vital to the national security of the United States. There were many instances where those leaks had occurred. I mentioned several of them just before the recess. There was the secret United States Intelligence Board's report in which it estimated the Soviet Union's strategic strength and the Russians' first strike capacity, a matter of great importance to our defense effort. Well, that was leaked by a government official to a reporter who printed it in the press for the Russians' information. There was the disclosure by one of our senior officials, at least so the newspaper reporter said, of our secret fallback position, our final offer in the SALT talks, the strategic arms limitations negotiations in Helsinki in 1971. Our negotiators there, our negotiating team, were trying to achieve as much security for the United States as possible from nuclear attack. The package which we had on the table there in dealing with the Russians was asking them to stop the construction of all nuclear missiles, both land and submarine-based. But according to another reporter, one of our senior officials confided in him that we were willing to settle for less, that we didn't really expect to get that much security from the Russians, and that if they turned us down, we would be willing to settle for just a ban on construction of land-based missiles and let them go ahead with the submarine-based. Well, now, when that was printed in the newspaper and the Russians read it, you can imagine what that did to our chances of getting the more secure arrangement, the greater protection for our country. That was definitely a security leak which needed to be plugged. Then there was the release of the Pentagon Papers by Daniel Ellsberg, also in June of 1971. Of course, Ellsberg had been identified, so that case is somewhat different because the President's highest national security and foreign policy advisors had warned him that it was extremely important that these officials who were leaking this information be identified and stopped. Well, Ellsberg had been identified, but it was by no means certain that he would not leak more information. Only part of the Pentagon Papers had been published at that time. It wasn't known whether he would go ahead with the rest, and there was also reason to believe that he had additional information. John Ehrlichman, in an affidavit, a sworn affidavit in April of this year, testified that in the week or 10 days after the publication of the first Pentagon Papers, these papers which related to our decision-making processes in a war which was still going on, in which American troops were still in combat, which Kissinger was trying to settle in sensitive negotiations in Paris. Ehrlichman said that Henry Kissinger met with him and the president and told them about Ehrlichman, about Daniel Ellsberg, and told them that he was, and I quote, in knowledge of very critical defense secrets of current validity, such as nuclear deterrent targeting. And I'm reading from page 621 of Book 7, Part 2. And I continue the quote. Having never heard of Ellsberg before the theft of the papers, my impression from Kissinger's description was that the nation was presented with a very serious potential security problem beyond the theft of the largely historical Pentagon papers. I later learned that the papers themselves were believed by defense experts to contain vital secrets. Dr. Kissinger told the president that the theft made very difficult our foreign relations with allies with whom we shared classified information. In these meetings, both the president and Dr. Kissinger were obviously deeply concerned, end quote.
Gentleman has consumed 5 minutes.
One additional minute, Mr. Wiggins.
Gentleman is recognized for one additional minute.
How the president, ladies and gentlemen of the committee, felt on the advice of his closest foreign policy and national defense advisors that he had to act to protect the national security to stop these leaks. In my judgment, and perhaps yours, he acted unwisely in setting up this special investigative unit, headed by a brilliant young man who had no investigative experience. I believe, and I think you do, that it would have been much better to rely on the FBI, which had experience in this field and would have known the legal limits and the practical limits in which to carry out a proper national security investigation. But is the President of the United States to be impeached because he made an error in judgment, because he was not perfect in his decision to act quickly and necessarily to protect the national defense? Is it a high crime and misdemeanor not to be letter perfect in the performance of your office? I think not, and I think this alleged ground of impeachment simply should not receive serious consideration by the committee.
Gentleman has consumed another minute. I recognize the gentleman from California, Mr. Waldy, for 3 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I think this particular issue is one of the most serious offenses alleged against the President. It relates back to one of the remarks that I made in the opening session of this committee when I suggested that the liberties of this country were enormously fragile and had been subjected to an assault, the likes of which we have not seen in our lifetime. And I think this particular case, the Fielding break-in particularly as an activity of the plumber, indicates the insensitivity of the President to the constitutional obligations that he had as the President of this country to protect the people in their liberties. One of the basic stability points of a free society is that the law enforcement authority of that society is accountable. And the moment you destroy accountability of law enforcement authority, you jeopardize and endanger freedom of individual citizens. And when the President denied the opportunity of the legitimate law enforcement institutions of this government, the Federal Bureau of Investigation and the Central Intelligence Agency, denied taking his problems with security to them for resolution, and sought to set up an extracurricular secret police force accountable to no one in this government or in this society except to the President individually and as a person, he, in my view, was in a major way interfering with the constitutional protections that have been set up to protect liberty. Now, for the President's defenders to suggest that it was an extraordinary departure from the institutions of law enforcement, but warranted because of the threat of national security, the burden is then clearly upon them to establish that the activities of the plumbers were in fact designed to protect the national security. And I call attention to what I thought was a very important statement of my colleague, Mr. Conyers from Michigan, where he pointed out that we must now, once and for all, draw a line with the use of national security as an excuse for all sorts of illegal and illicit activities generally that result in erosion of freedom. And just to test whether or not national security really was the purpose of this burglary in California when Dr. Fielding's offices were burglared by the plumbers to procure access to the psychiatric files of Daniel Ellsberg, allegedly for a national security purpose, but in reality to interfere with the trial that was to begin involving Dr. Ellsberg, you only have to examine the language of the President in his conversations with Mr. Dean on March 21st and March 17th.
Time of the gentleman has expired.
Well, I appreciate that. It's hard for me to complete a sentence when I want to analyze a conversation, but let me just... I appreciate that. I do appreciate that. I referred to March 21st, and the conversation that I will be reading will be a description of how the Ellsberg case became a national security case. The President is told by Dean about the break-in out there, and he says, the President said, "I don't know what the hell we did that for." And Dean said, "I don't either." And the President said, "What in the name of God did that?" And then move on to page 112 of the March 21st transcript. And the President says, properly, it has to do with the Ellsberg thing. "I don't know what the hell." And Haldeman says, "But why?" The President says, "Yeah, why? I don't know." The President says, "What is the answer on that? How do you keep that out?" "I don't know." "Well, we can't keep it out if Hunt." You see, the point is it is irrelevant. Dean says you might put it on a national security ground basis, which it was. Haldeman says it was, and Dean says, "And just say that," and the President says, "Yeah." And
The other minute of the gentleman has expired.
well, I really didn't finish the sentence.
Well,
It's a long sentence.
I think you have. Mr. Chairman, how much time do we have remaining on this side?
The gentleman from California has 8 minutes remaining.
I'll be happy to yield 4 minutes to my colleague from Ohio, Mr. Latta.
The gentleman from Ohio is
Thank you,
recognized
Mr.
for 4
Wiggins.
minutes.
I think the gentleman from California used about the longest minute we've had thus far. Well, let me say, he mentioned one conversation that I think that we ought to go back to a prior conversation. His minute didn't permit him to do that. And I have reference to the first time that the President of the United States found out about this, months after the break-in. And that's the conversation between the President and John Dean on March the 17th, 1973. Let's read that. Dean, the other potential problem is Ehrlichman's, and this is, and the President spoke up and says, in connection with Hunt. Dean says, in connection with Hunt and Liddy both. And the President inquires, they work for him? Dean, these fellows had to be some idiots, and we've learned after the fact. They went out and went into Dr. Ellsberg's doctor's office, and they were geared up with all this CIA equipment, cameras and the like. Well, they turned the stuff back into the CIA some point in time and left the film and the camera. Good sleuths, I might interject. The CIA has not put this together, and they don't know what it all means right now. And the president says, what in the world, what in the name of blank was Ehrlichman having something, and this is unintelligible, in the Ellsberg? This is the first time he ever heard of it, months after this had taken place. Dean says they were trying to, this was a part of an operation that in connection with the Pentagon Papers, they were, the whole thing, they wanted to get Ellsberg's psychiatric records for some reason. I don't know. President, well, this is the first I ever heard of this. Unintelligible again, and perhaps some expletives that were deleted. Care about Ellsberg was not our problem. And Dean says, that's right. Now, the gentleman from Iowa has mentioned something about the FBI not getting into this case, and I think we better talk about that. It was brought out before our committee that the late J. Edgar Hoover happened to know the father-in-law of Mr. Ellsberg. And the FBI was not responding to the prodding of the administration to get on with investigating these leaks, to which I shall refer in considerable length when we get on general debate on the articles themselves. And Mr. Chairman, I yield back the balance of my time to Mr. Wiggins.
How much time? How much is
Well, I'm waiting for him to rule. Mr. Chairman,
the gentleman has 3.5 minutes remaining.
Total.
Total.
May I be recognized?
Gentleman is recognized.
Mr. Chairman, it was my intention to discuss the Houston plan and to clarify for the benefit of our members the origin of that plan and to demonstrate that it was a plan of the top security people in this country recommended to the President of the United States, and he acted in pursuant to their advice, approved their plan for a period of about 4 or 5 days, and thereafter canceled his prior approval upon the recommendation of the Attorney General. I only intended to take the time on that subject because some of my colleagues seem to be concerned about that 4 or 5 day period of approval by the President of the United States in 1970. Rather, in my remaining moments, Mr. Chairman, I want to try to place this Plumbers issue in its proper focus. The question is not whether the creation of the Plumbers was justified. There is no law, nor regulation, nor rule, nor act of Congress prohibiting a President of the United States from establishing a unit within the executive branch for the purpose of coordinating intelligence activities. That's not the issue. The issue, rather, is whether or not the activities of that unit, once created, constitute an impeachable offense with respect to the President. We know that they do not, unless the President approved them, had knowledge of them, acquiesced in them, condoned them. Well, we now know, as a result of the splendid contribution of my friend from Ohio, that the President did not learn of these activities with respect to Dr. Fielding for nearly 18 months after they happened. The first time he learned about it. And now the question is, should he be impeached? Should he be impeached because he took an improper act upon learning of that activity? The President, without question, ladies and gentlemen, without question, regarded the Pentagon Papers matter as a national security issue. It is idle to talk about whether a conviction is proper under the Espionage Acts. Those acts, as my colleagues at the desk know, involve aiding a foreign power. It wasn't the motive of Dr. Ellsberg, ladies and gentlemen. It was the fact of disclosure, whatever his motive, that prejudiced the United States of America. And the President's actions were prompted by reason of the fact of disclosure rather than any subjective motive of Dr. Ellsberg to aid a foreign power, a fact which would be very important in a prosecution under the Espionage Acts. That's the issue. That's the issue, whether or not after the 17th of March, 1973, when the President learned of an act which happened about a year and a half prior to that, whether he acted prudently, given his state of knowledge and belief at that time. And I'm telling you that the weight of the evidence, the overwhelming weight of the evidence, is that Richard Nixon believed the Pentagon Papers issue was a national security issue. And his actions after learning in March of 1971 were wholly consistent with that belief on his part. Now, if a majority of this committee really believes that a president of the United States should be impeached because his honest and good faith belief that the security of this nation is in jeopardy and that decisive and bold action is required on his part, then so be it. But, ladies and gentlemen, you live with that judgment. History is going to judge you ill if you make that judgment. This is not a proper grounds to impeach the President of the United States. I yield back the balance of my time.
Recognize the gentleman from Maryland, Mr. Sarbanes, for 3 minutes.
Thank you, Mr. Chairman. I think it's very important for the members of this committee and the American people to appreciate exactly what the Plumbers did in the Fielding break-in. The Plumbers broke into Dr. Fielding's office. Dr. Fielding was not under suspicion. They went into his office in order to get one of his files on one of his patients. And I ask every doctor and lawyer and insurance agent and accountant in the country, what kind of land would you be living in if a group of hired hands have the power to come into your office in the dead of night in order to get one of your files? If the purpose was legitimate, why didn't they obtain those files in a lawful manner? And the answer to that is, of course, the purpose was not legitimate. Who were the Plumbers? They were a band of hired hands. They were not law enforcement officials. Why wasn't the FBI brought into this matter if it was a legitimate matter for governmental action? Because the Plumbers were doing absolutely illegal things that the FBI refused to do. And that does go back to the Houston plan of the previous year, when this fellow Houston put forward to the President and had it approved a plan that involved surreptitious entry in a memo that says the activity involves illegal entry and trespass. And the FBI added a footnote to that report and said the FBI is opposed to surreptitious entry. That same Houston report provided for covert mail coverage. And the FBI added a footnote and said the FBI is opposed to implementing any covert mail coverage because it is clearly illegal. They could not use the FBI because the FBI was not prepared to do these illegal things. Let us look at one other thing. From whence did the Plumbers get their money? Where did the money come from in order to do this operation? Ladies and gentlemen, it came from private sources. Mr. Baruti, a PR man here in Washington, a close friend of Mr. Colson's, states in an affidavit in the latter part of August or on the first part of September, Mr. Colson telephoned me and told me that the White House had an urgent need for $5,000. So he took $5,000 over to Colson's office, and they told him to go down to an office and give it to the fellow that he would find there. That was Eagle Crow, the head of the Plumbers unit. So Baruti goes down there with his $5,000 in cash and gives it to Crow. He takes it in there. They said, "Did you look in there to see what it was?" I looked in the envelope to see this was money inside of it. It was in the form of cash. Had you stated to Mr. Colson anything about the form in which you wanted the funds? Yes, he wanted them in cash. Why? I believe because it was felt that there shouldn't be any way to trace the money that was used.
The 3 minutes of the gentleman has expired. I recognize the gentleman from Massachusetts, Father Drinan, for 3 minutes.
Thank you, Mr. Chairman. This fiasco called the Plumbers had three names. It started out as Project Ellsberg. David Young named it the Plumbers, and the president, 18 months later, gave it the name of Special Investigative Unit. It was political and covert and unlawful from the beginning. Patrick Buchanan had the good sense to decline the job that was offered to him to be head of the Plumbers. And on July 8, 1971, he gave the best description of the purpose of then Project Ellsberg. He wrote in a memo to Mr. Haldeman that this is a project for a 3-month period to link the Pentagon Papers with the left-wing newspapers and people of America. There was no national security involved. Mr. Pat Buchanan had an alternative, which he thought was better. Let's undertake a major public attack on the Brookings Institution. Everyone had hysteria over the Pentagon Papers except Melvin Laird. 10 days after they were released, he said that 98% of the Pentagon Papers could have been and should have been declassified. The hysteria, I assure you, was created months after when the identity of the Plumbers came out. In Mr. St. Clair's brief on page 94, he said that the Special Investigative Unit was created, quote, in an entirely legal manner. And I doubt if he can support that, because this is entirely outside the ordinary way that the executive branch of government operates. Mr. St. Clair concedes at a moment in time that there was a shift in the unit's way of acting, but he said that the purpose was legitimate. He failed to tell us why they had sterile phones, whatever they are, in this little cubbyhole in the executive office building, and why you needed special passes to enter this section, and why, in total defiance of the law of the CIA, they regularly violated that prohibition against any internal security matters of the CIA. Mr. Henry Peterson testified before this committee on July 12, and he said there is no area of violations of federal criminal laws which is not covered by existing statute, and that if there is any residual jurisdiction, it goes to the Department of Justice. I suggest, therefore, that this was political and unlawful from the beginning, and the names came later. If the president says that there's an epidemic of leaks, that is not substantiated by the evidence. And let me quote you one justification that has come out today in a minority report from this committee that demonstrates that hysteria is still going, and with that I close. And this statement says, in justification of the Plumbers, that foreign espionage agents can read English and they can read the New York Times. Thank you very much, Mr. Chairman.
Time of the gentleman has expired. I recognize the gentleman from Maine, Mr. Cohen, for 3 minutes.
Thank you, Mr. Chairman. I'd like to direct my attention to the final sentence of this paragraph, whereby the President attempted to prejudice the constitutional rights of the accused to a fair trial. Several days ago, the gentleman from New Jersey made a statement that we must view the totality of the evidence, and I happen to agree with Mr. Sandman. He is absolutely correct, because only by viewing all of the evidence can we trace the threads of attitude and action that weave a pattern of spirit and conduct that is the very basis of our investigation. I want to call your attention to the September 15, 1972 conversation between the President, Mr. Haldeman, and Mr. Dean, whereby Mr. Dean indicated he was talking about Edward Bennett Williams, which time the President says, we're going after him. Haldeman, this is the guy we've got to ruin. And then I'm skipping on to page 10. I think we're going to fix, and I'm paraphrasing the SOB, believe me, we've got to, because he's a bad man. Now, I think this statement is relevant with respect to the Ellsberg matter, because Mr. Colson told us, as he told the court, that on several occasions the President urged Colson to disseminate information about Ellsberg and also his attorney, and this is the same act for which Mr. Colson pled guilty to corruptly endeavoring to obstruct the criminal trial by devising and implementing a scheme to defame and destroy the public image and credibility of Ellsberg. Now, Ellsberg, in my opinion, and I agree with Mr. Hogan, he should have been prosecuted, but his trial should have been gone to its full conclusion according to due process of law. What was done in Ellsberg reminded me of what Commodore Vanderbilt said to his adversaries: I won't sue you, I'll ruin you. The administration did not just seek to sue or prosecute Ellsberg for his wrongdoing, they set out to ruin him. And that, ladies and gentlemen, of this committee is not only contrary to the spirit of our Constitution, it is also contrary to the law, as stated in the cases of U.S. against Krogh and Colson. A man cannot set attack dogs loose with general instructions to stop and destroy leaks at any cost and then say that he is not responsible when the constitutional rights of citizens are shredded in the process. I yield to the gentleman from Maryland.
The gentleman has 1 minute remaining.
I'd just like to return to the wiretap matters that I wasn't able to finish earlier. In addition to the Kraft wiretap having no criminal or national security basis, it was done by a consultant to the committee to re-elect the president, which makes it totally illegal. In addition, under normal procedures, the Attorney General reviews the necessity and propriety of wiretaps on national security matters every 90 days. And this practice was not followed in respect to any of these 17 individual taps that the president had authorized and approved. Now, I'd like to read from a transcript of a conversation between the president and Dean on February 28, 1973 on wiretaps, when they were just talking about the Time magazine story which revealed the wiretaps at the White House. The president says, "Sure, and the Henry staff, he insisted on Lake, you see, after working with McGov for Muskie." And Dean says, "Uh-huh." And the president says, "Incidentally, didn't Muskie do anything bad on there?" Unintelligible, Henry, unintelligible. "At least I know not, because I know that. I know that he asked that it be done, and I assumed that it was Lake and Halpern. They're both bad." This is the president talking. "But the taps were, too. They never..."
Time of the gentleman has expired. All time has expired, and the question now occurs on the Wiggins amendment to strike paragraph 3. All those in favor of the motion to strike, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it. The noes have it, and the amendment is not agreed to. I recognize the gentleman from Texas, Mr. Brooks.
Thank you, Mr. Chairman. Mr. Chairman, in this debate, we have neglected a most vital part of this article, being Section 1. I think it is very pertinent to this entire activity. It is a primary area of abuse that has subjected the American people to spying and prying. And in the interest of debate, in that all of those members who have an interest in presenting the facts on this matter, Section 1, and those who are opposed to it, I have an amendment at the desk to strike Section 1. Would so move.
The clerk will read the amendment.
Amendment by Mr. Brooks. Strike subparagraph 1 of the Hungate substitute.
And the gentleman from Texas is recognized in accordance with the rule recently adopted by unanimous consent. The gentleman recognizes that there's 20 minutes in opposition to the amendment and 20 minutes in support of the amendment. And the gentleman controls the 20 minutes in support of the amendment.
Mr. Chairman, I would ask that the time that I would use be deducted from the time of the opponents of this, so that the proponents of it would not suffer in any way and would have a full 20 minutes to utilize, which I would yield to them as they see as a request.
Without objection, it is so ordered.
Mr. Chairman, Mr. Nixon's personal involvement in efforts to misuse the IRS for political purposes in violation of individual civil rights is clearly documented in events that occurred on September the 15th, 1972. In the tape of a meeting between the President, Mr. Haldeman, and Mr. Dean, there is no question that there was some discussion as to how efforts were going to get the IRS to institute audits and investigations of Mr. Nixon's political enemies. Some of the evidence involving Mr. Nixon's efforts to misuse the IRS has not been made available to this committee. The transcripts submitted to us do not include the last 17 minutes of this meeting with Haldeman and Dean on September the 15th. And yet, Mr. Dean has testified that during that time, there was a specific discussion about the plan to use IRS for these purposes. Judge Sirica has listened to the entire tape and has announced in open court that those 17 minutes do indeed involved conversations relating to the abuse of the IRS. He has since made those 17 minutes available to Mr. Jaworski, but under the restraint put on him by the U.S. Court of Appeals, has been unable to provide them to the Judiciary Committee. And needless to say, Mr. Nixon has not made this portion of the tape available to us, despite his continuing protestation that he intends to cooperate fully with our investigation. Now, we can only use the evidence that we have. And that evidence, the September 15th tape, Judge Sirica's announcement, John Dean's testimony, the Johnny Walters testimony, clearly indicates that there was a definite, concerted plan to misuse the Internal Revenue Service for personal and political gain. Now, Mr. Chairman, our constitutional safeguards protecting individual rights against arbitrary and unrestrained government power mean very little to a president who would use the IRS for such distorted fashion. I would reserve the balance of my time for those who are opposed or in favor of this proposition.
Mr. Chairman.
Gentleman from New Jersey, Mr. Sandman.
I'm in an uncanny position, Mr. Chairman, because I can't figure out, as I couldn't yesterday, whether or not the proponent of the motion to strike really wants that motion carried. Now, if he does, he has my assistance. And I know of a lot of other people will give him their assistance. Now, before I comment, I would like to hear from the gentleman from Texas. Do you really want to strike paragraph 1? Let me know how I should proceed. Will the gentleman from Texas please answer?
I'd be pleased to answer. I thought I had made clear to my distinguished friend from New Jersey that in the interest of debate, of getting the facts about just what happened to the IRS, how it was used, who told them to do it, what they did, that I thought that we ought to have this motion so that the people of this country and so this committee can fully evaluate just what happened. And I want you to have every advantage of a full 20 minutes to discuss why it should be included.
That's fine, but I'm still wanting to know, do you want your motion passed? If
well,
you
to
want,
be
I'll
candid
supply
about it, when
a yes
you
vote.
offer a motion for debate purposes, you're not necessarily confined to wanting it passed, and
well,
certainly
then,
I do not.
Now stop using my valuable time. The public now knows what you're up to.
I'm glad to get you that time, Mr. Sandman.
I'm not going to yield you any more of that valuable time because it is obvious that this is a game. In fact, we've been involved in quite a few games here. And you aren't any more serious about striking this article than my friend from Alabama was yesterday in striking any of the articles that he tried to strike. I'm mindful of the fact that they tell me we have about a 20% audience, which is about 44 million people it gives you exposure to. And maybe you can convince them with some of your generalities. That's the purpose behind all of this. I know it, you know it, and 44 million people know it. Make no mistake about it. Now, I'd like to yield some time to some other members of this side, and I'd like to yield to the gentleman from Indiana, Mr. Dennis.
Thank you, Mr. Sandman. I would like to say, Mr. Chairman, that if I felt that the evidence here substantiated that the Internal Revenue Service had been misused and abused for improper, political, or discriminatory purposes, I would take a very dim view of that myself. I would do so even though such use, misuse, and discrimination has not been entirely unknown in past administrations, because that would not constitute a defense now, even though nobody bothered to fool with it then. I believe, for instance, that in his diaries, the late Drew Pearson says that the late Harry S. Truman turned the IRS loose on him at one time. And that doesn't make it any better if it was done now, but I think it's a good thing to bear in mind that we have a certain amount of pious hypocrisy in these proceedings from time to time. Now, the truth of the matter is that there really isn't any evidence connected with the president, again, if you please, which we're always sort of sloughing over here. The president did anything out of the way about the IRS at all. The only thing anybody even attempts to cite is the conversation of September 15th. And as a matter of fact, the president doesn't refer to the IRS in that conversation. He says, we have not used the power in this first 4 years, as you know. We have never used it. We haven't used the Bureau, that's the FBI, and we haven't used the Justice Department. He doesn't talk about the IRS, as a matter of fact. But the interesting thing is that all that conversation is talk anyway. Now, it's not good talk. It would be damaging talk if there was something to be shown that the president ever followed up on it. But I haven't seen anything in this record where the president did follow up on it.
The gentleman from New Jersey has used 5 minutes.
I reserve the balance of my time and request Mr. Brooks to take out the cutter again.
The gentleman from Texas is recognized.
Mr. Chairman, I would yield 2.5 minutes to Congressman Mr. Danielson from California.
Gentleman is recognized.
Thank you for yielding. Inasmuch as my distinguished friend, Mr. Sandman, and others request specificity on many of these items, I feel it's appropriate that it be provided. Within this field of the use of the Internal Revenue Service, there are other items than those mentioned by Mr. Brooks. For example, along in 1971 and 1972, Mr. John Dean, who had authority to work as liaison between the White House and the Internal Revenue Service, obtained confidential Internal Revenue information about a rather large number of people, and under his direction, efforts were made to have the Internal Revenue Service conduct audits on certain persons who were low on popularity within the White House. This is borne out on March 13, 1973, for example. In a conversation within the Oval Office, the President asked Mr. Dean if he needed anything from the IRS, and Dean responded that he didn't at that time. He said he now had sources in the IRS and could get whatever he needed without any further trouble. Along in the spring of 1972, the political campaign was warming up, and they thought, John Ehrlichman and others in the White House thought it would be good to get some information on Lawrence O'Brien, who was chairman of the Democratic National Committee. They had found that in an investigation of Howard Hughes, there was some information indicating a financial connection with Mr. O'Brien. So Mr. Ehrlichman in 1972 instructed Treasury Secretary Schultz to investigate and interview O'Brien about his tax returns because the president was interested. Thereafter, because of the inquiry, the IRS did interview Mr. O'Brien, and they furnished Schultz with the results of the interview. It didn't indicate anything particularly bad, so on August 29, Schultz, together with Treasury Secretary Schultz, together with Barth and Walters of the Internal Revenue Service, decided that they would do nothing further about O'Brien. They notified Ehrlichman that they were dropping the matter, and of course Mr. Ehrlichman strenuously objected. But they wouldn't leave it alone at that point. A couple of days later, in early September, Mr. Ehrlichman got in touch with Herbert Kalmbach, the president's loyal personal attorney and fundraiser, and told Kalmbach to go up to Las Vegas, Nevada, and plant the story with Hank Greenspun of the Las Vegas Sun, I believe it is. But Kalmbach, fortunately, refused to do so. But this is a part of the pattern of misuse of the Internal Revenue Service.
Gentleman from Texas.
Mr. Chairman, I would yield 2.5 minutes to the gentleman from Illinois, Mr. Railsback.
Gentleman from Illinois is recognized.
I thank the gentleman for yielding. This is one of the areas that I mentioned I was concerned about in my opening statement. I want to express that the feeling that I share the concern that was expressed by the gentleman from Iowa, Mr. Maine. Let me just say that this story is what I would call both bad and good, or good and bad. The story is bad in the respect that top officials of government clearly tried to misuse their power. Good in the respect that in this particular case, contrary to many of the other aspects of the Watergate affair, there were some good people in the administration that rejected and fought what I think was a blatant misuse of power. The facts are these that trouble me so much, and I realize that other administrations had been guilty of similar activities, but certainly I don't think on the massive scale that this was attempted. On September 11th, John Dean gave 591 names to the Internal Revenue Commissioner and asked him to audit those persons' returns. What is an IRS audit? What is an audit? Well, to begin with, the taxpayer is asked to furnish a full and complete justification for everything used within the tax return itself. The IRS agent has access to prior returns. An audit of civil cases can go back 3 years, and in a criminal case, if criminal fraud is suspected, they can go back without limit and check in any and all returns filed by the taxpayers. In a typical civil case, the agent must be provided by the taxpayer access to all records involving deductions, medical bills, information regarding outstanding loans, and other significant financial data. If the IRS agent suspects there's been income received and not reported, he will prepare a net worth analysis, and to do this, he will interview friends, neighbors, associates to determine a taxpayer's lifestyle. Oftentimes, the taxpayer will have to hire a lawyer or an accountant at an expense to him. Many of my constituents have complained about IRS audits. Now, the direct evidence that we have testimony by John Dean along these lines. This was conducted by Mr. Doerr of John Dean in secret session. This list of 591 names, they were a group of McGovern's supporters and contributors.
The 2.5 minutes of the gentleman has expired. I recognize the gentleman from New Jersey.
It's interesting to note that the gentleman from California, Mr. Danielson, has given me an opportunity to prove beyond all reasonable doubt what we've been arguing about. The specificity, it's a real word. And that's the thing that's going to be remembered here, because those who have that solid 27 seek to violate it so badly. Now, here is the whole case. Let me make an illustration of what this gentleman has said. They're willing to be specific, sure they are. Look at how specific he just was. He started out by saying on a number of occasions in 1971 and 1972, John Caulfield, a member of John Dean's staff, obtained some IRS confidential information. In any court in this land, would that kind of indefinite thing hold up? Of course it wouldn't. Let's go down to the next one. In the spring of 1972, the spring takes in 3 months. What part of the spring? He doesn't dare tell you because he doesn't know. That's why they don't want to get specific. And in that one, John Ehrlichman received some information and passed it on to someone else. The next thing he told you, during the summer of 1972, a span of 3 more months. Now, the 38 members here have tried more criminal cases than they ever want to remember. And there isn't one can tell you that this can hold up in any court in the land. Each of these periods is 3 months. When in 3 months? And you can go right on through the whole bit. It's just a whole conglomeration of generalities. That's why they don't want to get specific. They don't want to do this thing the right way. Never did. Now, we have valuable time, and I want to yield to my friend from California, Mr. Wiggins.
California.
I thank my colleague for yielding, and I'll only take a moment. But I do want to put in focus what my friend from Illinois has just said about this egregious act of John Dean. in going to the IRS with some 500 names of political opponents of the president. That is absolutely indefensible, ladies and gentlemen, and no one at this table, Republican or Democrat, friend or foe of Richard Nixon, condones for 1 minute that act. But you see, the president didn't know that. He didn't know that John Dean went to the IRS, and there isn't a word of testimony that he did know when Mr. Dean went. And it's important as well to know what the IRS told Mr. Dean. The person that told Mr. Dean was the appointee of the president, executing the president's instructions, I presume. And there's no dispute as to what Mr. Dean was told. And in so many words, and if you'll pardon the expression, he was told to go to hell. Now, that's what happened.
Would the gentleman
For
yield?
that, the president is not to be impeached. This whole case of IRS abuse turns on the conversation of September 15, and on that, we'll just have to submit that. And we'll study it, review it, and decide whether or not at that time the president approved of this, or whether it was simply a discussion in the context of the time 3 months before an election in this country. I'll yield back that time to my friend from New Jersey.
Mr. Chairman, I yield 3 minutes to the gentleman from Indiana, Mr. Dennis.
Gentleman is recognized for 3 minutes.
Mr. Chairman, continuing the situation, I think it's worth remembering that Commissioner Walters said on the occasion that Dean came to him that Dean stated that he had not been asked by the president to have this done, and he did not know whether the president asked that any of this activity be undertaken. And Mr. Dean stated here in this committee, in answer to Mr. Ellsberg, I don't know of any audits that were accomplished, and the Joint Committee on Internal Revenue Taxation found that, in fact, none of these people were audited. So that's the record on the situation as to what actually took place as against a political conversation on the 15th day of September. And there is no evidence in the record anywhere that the president ever made any request except a hearsay statement by Clark Molinoff, who says that Haldeman told him that the president asked for a report on Governor Wallace's brother, which wouldn't stand up in any court in the land. And there's no evidence that that, in fact, is the truth, and it's been denied by 2 or 3 other people during the course of the testimony. And as Mr. Ellsberg said, there are good people in this. There were Secretary Schultz, there's Commissioner Thrower, there's Commissioner Walters. All of them turned Ehrlichman's efforts and Dean's efforts down. There's no evidence of a presidential effort, and the thing that there is evidence of is that Secretary Schultz and Commissioner Walters and Commissioner Thrower were presidential appointments of Richard M. Nixon's. I yield back to the gentleman from New Jersey.
I yield 2 minutes to the gentleman from Ohio, Mr. Latta.
Thank you for yielding. I want to reemphasize, underscore in capital letters what's been said by the gentleman from California, Mr. Wiggins, that no one at this table condones any such request that Mr. John Dean put forth. And certainly if the President of the United States had put forth that request, I would think that would be an impeachable offense. Now, the question is, did he or did he not authorize John Dean to do this? As already been pointed out, when he went to Mr. Walters, he specifically stated that he was not there at the President's request. And I think it's important to note, when this whole matter was submitted to a Joint Committee on Taxation here in the Congress, which is controlled by the opposition party, that they made this report. The staff's investigation paid particular attention to the cases of those individuals mentioned in the press as victims of politically motivated audits. The Joint Committee staff has difficulty in discussing these cases specifically because of the problem this would present in violating the individual's rights of confidentiality. Now, this is the place I want to emphasize. However, in none of these cases has the staff found any evidence that the taxpayer was unfairly treated by the Internal Revenue Service because of political views or political activities? Now, this conclusion is further supported by the House Judiciary Committee's materials, this committee's materials. Commissioner Walters stated in his affidavit of May 6, 1974, with respect to the list furnished him by Mr. Dean, "At no time did I furnish any names or names from the list to anyone, nor did I request any IRS employee or official to take any action with respect to the list."
The gentleman has consumed 2 minutes, and the gentleman from New Jersey has 6 minutes remaining.
I'd like the gentleman from Texas to take the next time.
The gentleman from Texas has 11 and a half minutes remaining. Gentleman from Texas.
Mr. Chairman, I yield 5 minutes to the gentleman from Iowa, Mr. Mizvensky.
Okay. Gentleman from Iowa is recognized.
Thank you, Mr. Chairman. Mr. Chairman, this article is the article on abuse of power. To me, it really symbolizes what the drafters of the Constitution really meant. They were worried when they just came out of a revolution whether or not we, in fact, would find a president that would abuse that power. And you found that a gentleman from Virginia, Mr. Randolph, said that he really advocated the impeachment process, specifically because he was worried about that abuse of power. Abuse of a presidential power, because if the president would abuse that power, it could very well lead to, quote, insurrections by the people. And really what this particular provision, it's a committee provision which is saying that to guard against this abuse, we have to take a look. We have to see, which what the Founding Fathers didn't have at that time, the Internal Revenue Service, whether or not that's been abused. And I think why the gentleman from Illinois, Mr. Ellsberg, and also the gentleman from Iowa, Mr. Maine, are so concerned about this matter, and why some of my colleagues, in all due respect, are defensive, is because I think there's the realization that one of the greatest abuses that we have is the abuse of the IRS. Because I think there's the realization that it poisons the system. If you abuse the IRS, really what you're doing, you're poisoning the system, and to a great extent it becomes probably one of the most hideous of all the charges. And why? Because we all pay taxes. We know that the IRS has personal information. We know that it's based on voluntary action on the part of all of us. We know that it's based on honesty and our conscientious ability to pay our taxes. And we have, really what we have is a self-confession when we all file our taxes. We know that and we understand it. And I think why the apprehension sets in is because there's the realization that Richard Nixon's presidency has really leveled a serious blow in the area of the abuse of IRS. Now, you've had talk about the enemies and the enemy list. And I'd like to say that there's another area. What happens about taking care of your friends? And I have submitted before that one of the president's best friends is the president himself. And we'll have an article on that subsequent to the one that we're considering tonight. Now, what do we see about the friends? And why is the friends matter as significant as the enemies? Because if you impede the due administration of the Internal Revenue Act with a violation that someone may have done, and you say that in fact the IRS is conducting an audit of that particular individual, and then you get a directive from the White House saying, look, which we have direct testimony from that says that we have to take care of our friends and turn the IRS off of our friends. What does it mean? It means another kind of cover-up. It means another kind of protection. And that's exactly what's happened. And let me tell my friends, though we're in a constitutional issue, which I agree, and they're groping for criminal violations, that if you intend and you are part of helping your friends and stepping into an audit that is done by the IRS, that is an interference with the due administration of the Internal Revenue Act. and I only cite it as an example, which is not only a significant violation of our Constitution and abuse of office, but it's also a clear violation of Section 7212 that says that, in fact, if you interfere with the due administration of the Internal Revenue Service, you're subject to a felony and to being put in prison. And I would bring that to the attention of the members of this committee. I'd also say that, in all respect, the Joint Committee on Internal Revenue Taxation that took a look at this issue, what are they doing? That investigation is going on. And they, in fact, have asked for re-audits of those friends, those ones that have had direct contact and have been the closest associates and friends of the White House, and we have testimony direct that, in fact, the White House was involved. Now let's point to the one item that's very interesting to me. That's the whole focus on September 15th and the testimony by the gentleman from California, who I respect, Mr. Wiggins. No direct testimony. We have Mr. Dean just talking about it. He's talking about it supposedly in the abstract. Well, let me say this, that it's not in the abstract. It's right on target. Let's refer to March 13, 1973. And what do we see? We see direct involvement, direct discussion. Page 50. They're talking about issues. What does the president say directly? Do we need any IRS stuff?
The time of the gentleman has
direct
expired.
Involvement.
And the gentleman from Texas has 6.5 minutes remaining, and the gentleman from New Jersey has 6 minutes remaining, and the gentleman from New Jersey wish to be recognized.
I recognize the gentleman from Mississippi, Mr. Lott, for 3 minutes.
Gentleman is
Very much,
recognized.
Mr. Sandman. Mr. Chairman, this is certainly an area that can be used to inflame the emotions of the American people, because there are many out there that I know of personally that feel that they are harassed by IRS and don't feel that they're necessarily on anybody's list. But I think that there are some key issues and points that we must stress and keep in mind. There is no evidence of any such misuse in the final analysis on the part of the President. The Joint Committee on Internal Revenue Taxation's report should be noted in this conclusion, and I'm going to cite some sections from that report in a minute. Also, almost all of the examples of alleged attempts to misuse IRS come from the person that used the most influence, supposedly, within IRS to get these audits. John Dean is a person that made these points with John Walters and others. Now, a lot has been made of this missing 17 minutes of tape. Well, the fact is we don't have that 17 minutes. And there's already been some contradictions about what's included in those 17 minutes. So I don't think we can base this decision tonight on something that we don't yet have. And maybe we will later on, and we should consider it then. But it's been claimed that several individuals in the White House attempted to misuse the IRS for partisan political purposes. It's clear that such an alleged misuse could only succeed if it were supported by the power and authority of the President in the final analysis. On looking at all the evidence available, it's clear the President did not take that action. And one point I want to emphasize that Mr. Dennis made a while ago. These people that have been praised so highly, Mr. Schultz and Walters and Thrower, these people were appointed by the President, just as these aides were, like Dean. Now, let me quote to you some of the sections in the report from the Internal Revenue Committee. However, in none of these cases has the staff found any evidence that the taxpayer was unfairly treated by the Internal Revenue Service because of political views or activities. The staff believes that in 3 cases there are substantial questions about decisions made by governmental agencies about friends of the White House, but the staff does not have evidence that there was any pressure involved. The staff also believes that a number of enemies either were not audited when the staff believes they should have been, or were audited too leniently. And then in Mr. Dean's response after questioning by Mr. Ellsberg, he says, "So I don't know if the President got it back in it or not, or I don't know of any audits that were accomplished." In conclusion, I think that the record clearly shows that while some personnel at the White House may have indeed used improper intentions against the IRS, the fact is, in the final analysis, no IRS abuse resulted. Thank you.
The gentleman from New Jersey has 3 minutes remaining.
I reserve and yield to the gentleman from Texas to use some of his time.
The gentleman has 6.5 minutes remaining.
Mr. Chairman, I'd yield 6 minutes, reserving 30 seconds to myself. The 6 minutes I yield to the gentleman from Alabama, Mr. Walter Flowers.
I yield
Gentleman
1
is
minute
recognized.
of my time, and I thank the gentleman from Illinois, Mr. Ellsberg.
Thanks, Mr. Flowers. Let me just say, let's don't delude ourselves here. There was a conversation. The president was involved. The president knew exactly what John Dean had done on September 11th. Not only did he not turn it off, in my opinion, and according to John Dean's direct testimony, he told him to go back again. Now, some people argue that because nothing was done, that there's no serious offense. Why wasn't there anything done? Was it because the President of the United States decided to turn it off and register his outrage? It's because these investigations did not occur because there happened to be two rather dedicated public servants, one by the name of George Schultz, and then a rather good IRS commissioner that wouldn't have anything to do with it. And I think that Commissioner Walters gave very good advice to Mr. Dean. When he presented this list, he testified that he told Dean that compliance with such a request, and I quote, would be disastrous for the IRS and for the administration and would make the Watergate affair look like a Sunday school picnic.
I thank the gentleman for his comment. You know, my friends, a fundamental principle of our government is that equal justice under law is a guarantee to every citizen. Put it another way, we are a government of laws and not of men. This commitment to equal justice is written down in a few places, like in our Constitution and in our laws and in some court decisions. But I think just as important are some commitments to this principle that must be assumed in our society. For instance, the assumption that the sensitive agencies of government with peculiar power over each one of our citizens, like the police power and the power to tax, will not be abused or misused for political purposes. This is a fundamental source of the people's confidence in their government. We, the people's confidence in our government. That the president and his men should have trifled with this source seems to me sufficiently grave to qualify as a component of an article of impeachment. Can you imagine under any circumstances ever the President of the United States saying to an aide, "Do you need any IRS stuff?" Well, that happened on March the 13th, 1973 in the White House. Can you imagine the President's lawyer, his counsel, his close subordinate, saying with impunity and apparent approval of the President, "We have a couple of sources over there that I can go to. I don't have to fool around with Johnny Walters, who was our IRS commissioner. We can get right in and get what we need." That also happened in the White House. Let me turn to some specifics, which may be just the tip of the iceberg. There was a two-pronged attack on a well-known political figure who is now the governor of my state, and a great and courageous American, which I believe is shared equally, a belief I believe is shared equally by those who agree or disagree with him. In the spring of 1970, George Wallace was not governor of Alabama, but engaged in a heated contest with then-Governor Brewer, who had succeeded Governor Lurleen Wallace on her death in 1968. The decision was made by whom I don't know, but I think you can be certain it was in the highest councils of the White House, that the success of Governor Wallace in a Democratic primary in the state of Alabama was somehow incompatible with the interests of the Nixon administration. So what did they do? Well, at the specific instance of Mr. Higbee, primary assistant to Mr. Haldeman, chief of staff to the president, $400,000 in funds left over from the 1968 presidential campaign was funneled into Alabama in a devious and undercover manner in an unsuccessful effort to defeat Governor Wallace. There's direct evidence to this from Mr. Kalmbach before this committee in this room. Then in early 1970, H.R. Haldeman directed a special counsel to the president to obtain a report from the IRS about its investigation of George Wallace and his brother. Haldeman gave assurances that the report was for the president. A report from IRS Commissioner Thrower was requested on this basis, received, and given to Haldeman. Material contained in the report was thereafter transmitted to Jack Anderson, a syndicated columnist, by Murray Chotiner, a White House aide and personal confidant of the President. Portions of the material potentially dangerous politically to Governor Wallace were published nationally on April 13, 1970, several weeks before the primary election. Now, both of these foregoing actions were a gross abuse of the IRS as an agency of government and, incidentally, a violation of federal law. Now, I ask you, my friends, who was it that maintained a political enemies list in an effort to get back at them? It was the administration of Richard Nixon. Who was it that released potentially damaging tax information about the governor of Alabama? The aides of Richard Nixon. And on another subject of gross abuse, who was it that frustrated that ultimate date with justice that awaited Daniel Ellsberg and Anthony Russo, and which I trust would come to them at the hands of a jury? Was it some left-wing radical liberal plot? No, my friends, it was the administration of Richard M. Nixon. However you describe yourself and wherever you may be, you ought to be vitally concerned here, because if this president, with whom you perhaps agree politically, can get by with the abuses described in this article, then so can succeeding chief executives, including those with whom you do not agree, thus imprinting in the standards of our highest office a standard of conduct that is certainly unacceptable to me.
Time of the gentleman has expired.